The senior advocate of Nigeria, Robert Clark, has opposed those claiming that the presidential candidate must score a minimum of 25% vote in the Federal Capital Territory, Abuja, to be eligible to be declared winner and president of Nigeria. While speaking in an interview with Channels TV, he noted that the Supreme Court had made it clear in some cases that it did not impose any privileges on Abuja. Speaking further, Robert Clark, SAN, says that it does not make any sense for anyone to say that the candidate who has 25% in the needed state but fails to score 25% in the Federal Capital Territory, Abuja, should not be declared the president of Nigeria. This is a very big issue for determination and very contentious in nature. However, when you look closely to the provisions of the Constitution of the Federal Republic of Nigeria 1999 and the already decided cases of the Supreme Court, it is safe to say and infer that Abuja is not a state, but we accord it and give it state privileges, as the Supreme Court has decided that Abuja is Abuja and will not be given any privileges because it is not a state, but we regard it as a state. Robert Clark further asked a question that if a man has 25% in 36 states but does not have any in Abuja, would you say that he shouldn't be the president of Nigeria? It does not make any sense. So we should be very careful on the issue, because by dragging Abuja into this subject matter, we now have 37 states. And is it possible that a man can have two-thirds of 37 states in an election? If we say Abuja is a state, why does Abuja not have a governor? Well, this is really an area that we need lots of expert knowledge, because we as citizens are as confused as ever as to the position of law. And a lot of people also have made their contributions, and they've come out to argue that when the requirement of the 25% is not met, there should be a rerun of the election to determine who really is the winner and who should assume the position of the president of Nigeria. If we also go down history and do our findings, we'll discover that there is no president before our current newly elected president who has assumed the office of the president of the Federal Republic of Nigeria without winning the Federal Capital Territory, Abuja, in the election. So this is a breaking history in Nigerian elections since 1999. Now the question is, why is the Supreme Court silent on this issue? Why go ahead to swear in the declared presidential winner without resolving the issues bordering on the election? We should recall that the nation went through a somewhat complex and controversial presidential election on February 25th, 2023, and the candidate of the All Progressive Congress, Senator Bola Ahmed Adekunle TINUBU, who was declared winner by the Independent National Electoral Commission (INEC), has since been issued his certificate of return. It has become the norm that practically every election in Nigeria is contested in court. The 2023 presidential election is no different. Two of the other leading candidates in the contest have since proceeded to court to commence the process of challenging TINUBU's victory at the polls. The present debate amongst legal pundits is whether a presidential candidate must score at least 25% of all the votes cast in the Federal Capital Territory, Abuja, FCT, aside from the other two conditions precedent to be declared winner of an election. INEC's declaration of TINUBU as the winner of the presidential election clearly emphasizes the fact that the electoral body doesn't believe that 25% of the votes cast in the FCT must be secured to win. The crossfire in these controversies is on the interpretation of Section 134, Sub 2B of the 1999 Constitution of the Federal Republic of Nigeria, which makes the provisions of the issues in controversy. So many legal pundits, some of which are Dr. Olisa Abakoba, SAN, Femi Falana, SAN, Distinguished Professor Taiwo Osipitan, SAN, have all made their own contributions as to the various interpretations to the aforementioned constitutional provisions and their answers to the burning issues in question. Dr. Olisa Abakoba, SAN, interpreted Section 134 Sub 2B of the 1999 Constitution as amended and says that it is clear and unambiguous, direct and simple. To be declared presidential winner, a candidate must secure at least 1/4, which is 25% of the votes cast in 2/3 of the entire 36 states of Nigeria. That is in the 24 states. Also, the candidate must also secure not less than 25% of the votes cast at the FCT. The literal interpretation of this section is that a candidate must secure 1/4, which is 25% of the votes cast in 2/3 of the entire 36 states of Nigeria, and 1/4, which is 25% of the votes cast in FCT. This provision is so clear, direct, and unambiguous that you don't need a professor of constitutional law to comprehend. The use of the word "and" had been held by the Supreme Court to be conjunctive, which implies that the conditions in Section 134 Sub 2B are conjunctive and mandatory. He further stated that resort to Section 299, which states that the FCT is to be treated as a state in Nigeria, is a general provision that has no bearing on Section 134. A general provision cannot override a specific provision. Section 134 Sub 2B is a specific provision on the conditions for declaration of a candidate and the presidential winner at the polls. In conclusion, with the results of the general election as published by INEC, the contest is still open as none of the candidates has satisfied the legal threshold in Section 134. That is Dr. Olisa Abakoba saying. While Dr. Femi Falana, SAN, said that Section 299 of the Constitution provides that provisions of the Constitution shall apply to the Federal Capital Territory as if it were one of the states of the Federation. It means that the FCT is the 37th state. So Section 134 of the Constitution, which provides that not less than 1/4 of the votes cast at the election in each of at least 2/3 of all the states, and the FCT means 25%, 25 states or 24 states plus the FCT. Winning the FCT by a candidate is not compulsory. He cited the case of Baba Panya against President, Federal Republic of Nigeria 2018, where the Court of Appeal held inter alia that it is therefore doubtlessly clear that by virtue of Section 299 of the Constitution of the Federation, the Federal Capital Territory is in law a state. In other words, the Federal Capital Territory should be treated as one of the states in the Federal Republic of Nigeria. It follows, therefore, that bodies like the Federal Capital Development Authority are to be regarded as an agency of a state. independent of the federal government, it would appear that only relationship existing between the federal government and the Federal Capital Territory is that its executive and legislative powers and duties are exercised for it by the President through the Minister of Federal Capital Territory and the National Assembly respectively. From the provisions of Section 299A, where the President through the Minister of Federal Capital Territory acts, he does so as a governor of a state. So also, where the National Assembly legislates for Abuja, it does so as a state House of Assembly. Thus, by the combined effect of Sections 134 and 299 of the Constitution, a candidate shall be deemed to have won the presidential election if he scores the highest number of lawful votes cast at the election and 25% of the lawful votes in 37 states or 36 states plus the FCT. It is not compulsory for a presidential candidate to win the FCT. The FCT is not Electoral College of the Federal Republic of Nigeria. While Femi Falana, SAN, says you don't need 25% of FCT votes to win.